Today's Supreme Court order may not have been exactly what Pasadena-based Harvest Rock Church wanted in its case against California's COVID-19 restrictions. It did not get the same ruling the court made in a similar case in New York State.
They said, we're not going to give you that order, but what we're going to do is we're going to send this case back down to the court that looked at this, and they're going to have to decide whether, in fact, they should grant an order or not in light of the decision that we made.
The McGeorge professor of law, Leslie Jacobs, says the order could be seen as encouraging for the church's case.
That it will require the lower courts here and probably other places too, because we'll see more of these, to look at our state's order and the claim by Harvest Rock in light of what the Supreme Court said with regard to the New York order.
However, Jacobs points out the circumstances in New York and California are very different. New York severely limited capacity at houses of worship across the board based on mapped out zones. And the New York case had evidence of discrimination against the Orthodox Jewish community.
There was some evidence on the record, statements, and then also the way the lines were drawn that made the court say, this looks like maybe you're treating religion specially.
Jacobs says California's tier system is much different from New York's zone system because it adds explanations for each tier.
Governor Newsom, in the order, the tiers, has offered reasons, and a court will say, well, are those reasons enough, and do they exist?
Plus, Jacobs says a court will also recognize California's warmer climate.
Outdoor services, I will point out, we're California, not New York, so that's a little more plausible to do, and a court would consider that.
But in the end, Jacobs says that Harvest Rock's legal argument is a strong one based on the United States Constitution's First Amendment, claiming Governor Newsom's order is illegal because it treats churches differently from other non-religious groups and activities.
Their claim is, and shopping malls can be open at a lower percentage, but some indoor activity can happen there and retail, and they say that's not fair, there's no difference. And so that's what a court will be looking at.
In Sacramento, Doug Johnson, Fox 40 News.